Ladies and gentlemen, good evening, and thank you very much for coming. Those in person and those online, we very much appreciate it. Tonight is the 28th Goff Arbitration Lecture. We've been running this for some time now. And before we start, I just want to give you a cue. There is a book out there with the whole series. So if you're interested, please go and purchase it. Okay, thank you very much. Now, without further ado, I'm going to actually welcome Thomas Cross, Professor Thomas Cross. He's basically an Associate Dean from the City University School of Law, and he'll give the opening remarks and the introduction of our distinguished speaker today, Mr. Gleason, SC, and hopefully you can actually listen more from Mr. Gleason going forward. Thomas?
Yes. Good evening, ladies and gentlemen. On behalf of the Law School at City University of Hong Kong, I'd like to welcome you to the 28th Goff Arbitration Lecture this evening. The Goff Lecture was instituted in 1990 by City University School of Law to celebrate the commencement of our Master of Arts in Arbitration and Dispute Resolution. The first lecture was delivered by Lord Goff of Cheveley, Lord of Appeal, who then consented to the series bearing his name. The Goff Lecture provides an excellent opportunity for discussion and exchange of views among practitioners and academics in the field. The 27th Goff Lecture was delivered by Chief Justice James Alsop of the Federal Court of Australia. And tonight, we're very honoured to have Mr. Justin Gleason, SC, here with us. Justin Gleason is an international arbitration practitioner and barrister practicing at the Australian Bar. Between 2012 and 2016, he was a Solicitor General of the Commonwealth of Australia and advised the government on matters of international, constitutional and public law, as well as leading the Australian legal team in proceedings in the ICJ and PCA against Japan, Timor-Leste and Philip Morris Asia. In international arbitration, Justin has numerous positions as presiding, single or co-arbitrator. He's a fellow of the Australian Academy of Law, a fellow of the Chartered Institute of Arbitrators, a fellow of the ACICA, and a member of the SIAC panel of arbitrators. He's published extensively and delivered numerous presentations and lectures on topics of international law, arbitration, and constitutional law. I'd also like to take this opportunity to introduce one of our programs, the Master of Laws in Arbitration and Dispute Resolution. It's the first master's degree program in arbitration and dispute resolution in Asia. It provides an understanding of the theoretical, practical, and ethical problems relating to arbitration and dispute resolution, and is a stepping stone for professionals to become more involved in arbitration, mediation, and other forms of alternative dispute resolution. It's the first program recognized by the Chartered Institute of Arbitrators to offer the course Advanced Award Writing in Hong Kong. Ladies and gentlemen, please join me in welcoming Mr. Justin Gleason.
Well, thank you very much for that introduction, and it's a great pleasure for me to be here with you tonight. Could I start with a personal reminiscence? In 1984, which was a few years ago for me, and perhaps for one or two others, I was a young student from Sydney, and I had the privilege of studying in Oxford University, and I was there first introduced to the work of Robert Goff, both his textbooks and some of the cases he had already started to decide, including the very famous Barclays Bank and Sims. And just yesterday, the High Court of Australia delivered judgment in an appeal in a restitution matter in which I was fortunate to appear as counsel, in which those very words of Robert Goff were again considered in determining whether there was a novel defence to a claim for recovery of illegally levied rates. Now, that's only one of his many contributions, but it's an indication of them. Could I also acknowledge the distinguished previous speakers in this series, about which some more will be said when the book launch point is reached. I want to start tonight with a bold claim, which a barrister should never do, and of course an arbitrator never does, which suffers potentially from overgeneralisation. And it's in the title of my lecture, and it is a generalisation that as between the common law and the civil law legal systems, there is a degree of incommensurability in the methods by which facts are found. And by that I mean the methods of pleading, evidence assembly, the conduct of the trial, and the ultimate fact-finding process are different, significantly different, due to historical forces which remain extant, at least to some extent today. The link between that proposition and arbitration is that I consider that international arbitration is well placed to bring together conflicting systems of legal process. Indeed, it can be described as a rich and diverse laboratory. We know that it's based upon party autonomy, which calls for a fair, efficient, and presumptively binding process. But I would suggest international arbitration also serves a semi-public goal, which is sometimes not appreciated. And the nature of that semi-public goal is that the better international arbitration performs, drawing upon the rich resources of different and conflicting legal systems, the more it can in fact contribute to the improvement of those domestic law systems. And as someone who was fortunate enough to have moved between private law, particularly in Australia, and in recent years, international arbitration and public international law, I have seen how that interchange is taking place, and some of the very excellent things occurring in arbitration and international law are in fact, I suggest, informing the best domestic process in our various legal systems. Now, tonight I'm only speaking about this interplay between the common law and the civil law, and I of course recognise that there are other equally important legal systems, but I can only concentrate on that interplay in the time we have available. My remarks will be in four parts. The first is a conspectus, and it can be only that, of common law process. The second, which I offer hesitantly, since I'm not practiced as a civilian lawyer, but it is a conspectus of civil law process, at least as I understand it, from my direct observation of it and my study of the German Civil Code and the French Civil Code, when civil law deals with the same problems I'm going to address. The third part will be a brief summary of how I see those two processes coming together in international arbitration. And the final part will be some suggestions, my own four humble suggestions for how we can do even better in international arbitration if we're sensitive to the different legal systems that are coming together. So as to the first part of my talk, while it may appear trite, to those trained in the common law, the very basis of the crystallisation of the issues lies in the pleadings, and the pleadings are documents designed to identify disputes of fact, and they are not there to provide the evidence or the legal authorities or the full argument of the parties. That has been the tradition going back hundreds and hundreds of years to the United Kingdom, and then practiced in most of our common law jurisdictions. Now, that nature of the pleading then informs much of the process that follows, because discovery will be governed by the issues in dispute, determined through the pleadings, and it will often be not until close to the hearing that you will actually see the full evidence that's going to come from your opposing party. And what that means is that when we come to the common law trial, the essence of the trial is that it is a single concentrated affair in which each party will present the whole of its evidence and its legal argument in a single uninterrupted sequence in which the principle of orality is central. And that, as we know, for those of us who are common law practitioners, means that a central feature of the trial will be the examination of the witnesses in chief, then through cross-examination by the opposing party, briefly in re-examination. That's the lay witnesses I'm speaking of. And when we turn to the expert witnesses, although there have been reforms over the last decade or so, it remains the case that the experts are called by the parties, they are hired by the parties, and they are witnesses presented for each party rather than being usually, as it were, court-appointed experts. And as a consequence of that, usually, at least, the experts may be subject to rigorous cross-examination, as would be the lay witnesses. Now, what I want to add about the common law process, which is relevant to my theme tonight, is that while in many cases, perhaps the majority, we no longer have trial by jury, we do still have the critical imprint of trial by jury upon the processes that the common law adopts. And let me give three instances. The first is the common law's devotion to strict and detailed and complex rules of evidence designed to determine what material can and cannot be put before the tribunal of fact, whether that be the jury or now more commonly a judge. Now, the rules have softened over time, but they still tend to be a complex body of rules running to hundreds of sections with very detailed commentaries. That's a particular common law feature that you will not generally see in a civil law system. The second manifestation I want to refer to is in the more basic question of what is actually happening in the common law hearing, in the common law trial. And what is essentially happening is that the court is making available as much time as possible for this critical examination of the witness evidence, particularly through rigorous cross-examination. And there's a strong belief to common lawyers, not often shared by civil lawyers, that it is the performance of the witness under this cross-examination, including the demeanour of the witness as well as the content of the answers, that is the best guide to determining where the truth lies. The documents are not unimportant and they provide the context, but there is a belief that the judge or the jury, using human skills in particular, can determine and distinguish the truthful witness from the false witness, the reliable from the unreliable. And a third feature, which I just mentioned in a sentence, is that the open justice principle is regarded as fundamental in common law systems. Now, let me turn to what happens in closing submissions. The trial ends usually with oral submissions to commence almost immediately afterwards, where it is the job of counsel to bring together the evidence and to persuade the judge to favourable conclusions. And Socratic dialogue is at the heart of this process, with the judge looking for answers to the questions that are troubling the judge and looking for answers to the best points which have been raised by the opposing party. I'd hesitate to observe, but because everything is a generalisation, but the traditional common law judge is not really interested in a grand set piece prepared speech at this stage. The judge wants the answers to the questions that are troubling the judge so that a detailed written judgment can be written accordingly. There are two matters that I want to conclude on the common law system, at least in this conspectus. The first is that while notions of fairness and due process are evident in all legal systems, they take particular forms given the history of the system. And in the common law system, there is a principle sometimes traced back to the House of Lords decision in Brown and Dunn, and sometimes simply embedded in one's blood, that it is essential in the cross-examination process that counsel put to the witnesses for the other parties the key propositions which will then represent the case in closing submissions. And if that is not done, it may well be considered to be either a breach of professional etiquette or simply bad advocacy. And so it's in the blood of the common law system that counsel on each side will comply with that Brown and Dunn obligation. And my final observation is that, in a sense, the common law system, heavily adversarial in the way I've indicated, is searching out a relative truth. I don't say that critically, but I say it as an observation. It's a relative truth because what the judge is finding is what is the preferable version of the legal truth based on the evidence that's been called under the onus of proof, which one or other party bears, and in the light of the way the parties have chosen to join the case. It is not for the judge, save in the rarest of circumstances, to be searching out other pieces of evidence that have not been addressed by the parties. Now, let me turn to the second part, which is the civil law system. The differences that I would detect are these. Firstly, if we start with the pleadings, they serve a fundamentally different purpose because the initiating process, whatever precise title it takes under the various civil law systems, contains not just the factual case, but also exhibits or makes available all evidence which is currently available to the party, and usually will also include the legal authorities plus the full argument applying those authorities to the facts. Now, there are really two assumptions at least which underline that commencement of the civil law process. The first is that the best evidence is likely to lie in the documents rather than in witness testimony given orally at a hearing. And the related assumption is that the parties should usually have available to them before the dispute commences the evidence that they need to make good their cases. Now, it is that memorial process that shapes much of what follows in the civil law system. It explains why discovery or disclosure of documents is often much more rigidly restricted. And it explains why it is the judge, either the pre-hearing investigatory judge, perhaps in France, or the judge who will be hearing the ultimate case, perhaps in Germany, who will have the task of building the file or the dossier upon which the ultimate hearing will be based. And what I mean by that is that, unlike the common law approach, it will be the judge who will decide which of the witnesses offered by the parties are sufficiently important that their oral evidence should be received. It will be the judge, not the parties, who will decide what experts should testify, and they will testify as servants of the court. It will be the judge who will decide, even over the objection of the parties, whether the pleadings need to be reclassified to identify what the judge considers to be the true issues, that being a particularly potent mechanism in France. And that then leads to the civil law trial or hearing, likely to be much shorter in length than the common law hearing, under some systems spread over different periods of time, often, not always, losing the immediacy of the concentrated common law hearing. Sometimes, as often in France, all of the evidence has already been collected by deposition under control of an earlier judge, and the hearing itself may consist merely of oral pleadings. In that process, the documents will often be given greater weight than witness evidence. The judge will have this intense knowledge of the file. And when examination of witnesses does occur, whether at the hearing or prior to that, it will be an examination led by the judge. The role of the lawyers will be limited to being permitted to follow the judge and potentially ask some questions by way of clarification or addition. But in general, one will not see a strategic, continuous common law cross-examination being conducted either by the judge or by the counsel. The result then is that the closing submissions in a civil law trial permit counsel to be heard on what is described as the results of the taking of evidence, much of which has occurred under the judge's control, and usually there not being a strict sense of onus of proof. Rather, one is seeing the judge searching for a more objective truth, with counsel for the parties being assistance in the discovery of that truth rather than adversarial contestants who are the primary drivers of that truth. The result also is the Brown and Dunn principle that I mentioned has little role to play in a civil law system because cross-examination does not have the role it does at common law. So let me come to part three, which is what we see in modern international arbitration. What I suggest, allowing for the variances, of course, from case to case, is that we are seeing an interesting hybrid of the two approaches I've just described. If we think of the commencement of the proceedings, in general, the memorial process tends to dominate the first year of a major international arbitration. In that process, the parties present the whole of their case in a unified form, including the documents available, the witness evidence, and the legal authorities. So the commencement of international arbitration looks functionally like the commencement of a civil law hearing, I would suggest. The memorial process carries with it a significant benefit, which is that each party, and indeed the tribunal, has an early ability to gain a conspectus of the entirety of the case being made by the other party. That is a plus. Can I also suggest that from a common law perspective, a potential difficulty with some memorials, apart from expense, which is significant, is that in seeking to tell the overall story on either side, they often do not isolate with precision, as a very good common law pleading would, the true differences of fact which the tribunal must decide. Sometimes in the effort to tell the whole story, there are two ships passing in the night, and that can influence subsequent steps in the proceedings, including, for example, disputes over what documents need to be disclosed. I would suggest, as a positive of memorials, that a hard-working tribunal is able, through a careful scrutiny of them, to gain an early, detailed understanding of each side's case, and indeed to form provisional, I say only provisional, views on which issues are really going to matter in the ultimate resolution of the case, and potentially how those issues might possibly be removed. In doing so, the tribunal is operating more like a civilian judge, because at this stage, the tribunal has not seen a single witness live. But what the tribunal has seen is the documents, the depositions, the arguments, the legal authorities, and what is occurring to that extent has a civil law flavour about it. Disclosure of documents in international arbitration is something of a hybrid. It tends to have more of a civilian flavour in that tribunals seek to be relatively restrictive about what really needs to be produced. However, in some cases, it may be more generous than what one might see in a pure civil law system. But let me come to an aspect of the pre-hearing arbitration period, which is really marked, I would suggest, by an absence. Notwithstanding we have these detailed memorials, notwithstanding the tribunal is equipped with a good idea of the whole case being made by either party, absent a specific procedural order, we usually see a tribunal taking a hands-off approach to the selection of the witnesses, particularly the lay witnesses, which will give evidence at the hearing. The tribunal might take a more interventionist approach with expert witnesses, but even then, usually at least, the experts will remain party appointed, party hired, and party instructed. So what we tend to see, I would suggest, is something of a hands-off approach, more reminiscent of the common law, until we get to the hearing. Now, my empirical observation, and I'll be happy to hear the views of others, is that the hearing in a modern international arbitration tends to be shorter in length, considerably shorter than a common law hearing for a comparable dispute. A technical dispute in a common law court might be allocated 6 to 8 weeks to hear substantive expert evidence. In an arbitration, it may finish in a week or 10 days. Now, the words of Thomas Hobbes come to mind, that the hearing in international arbitration can tend to be nasty, brutish, and short. I don't say that critically, but there is an emphasis on a very tightly confined hearing, and that tends to make it look a little like a civil law hearing. And what I suggest follows from that is that while we tend to see cross-examination in an international arbitration, which looks like we're in a common law hearing, and by that I mean examination driven by counsel in a strategic, continuous sense, not examination driven by the tribunal, the cross-examination will usually be shorter, significantly shorter than it would be in a full common law hearing. And yet, and there's always another and yet, it will often tend to be highly confrontational and adversarial in that shorter period. And to my observation, civilian-trained arbitrators often find that type of cross-examination either unhelpful at best or distressing at worst. So we then turn to the experts. As I've mentioned, they're normally called by the parties, more like common law, although their cross-examination may tend to be much more contracted than at common law. And it is as if, standing back from it, the pre-hearing, heavily documentary presentation of the competing cases has been transformed overnight into a quasi-common law hearing, yet under tight civilian constraints. Civil law approach reveals itself in the primacy given to the documents and to the record of evidence created prior to the hearing, yet the common law approach reveals itself in frequently aggressive, even if truncated, cross-examination. That, I suggest, can lead to both an invitation and a potential danger for an arbitral tribunal. The tribunal will not be burdened by the common law rules of evidence. It will be permitted to consider anything and everything to form its overall assessments. And yet there's a potential danger that the tribunal has been confronted with the immediacy and the urgency of a sharply confined oral hearing, sitting very much like a common law judge or jury, and asked to form assessments of the witnesses, including their demeanour, but without having the full common law cross-examination, nor indeed usually full compliance with Brown and Dunn. And that presents forensic challenges both for counsel and for the tribunal. An astute tribunal will know that the opportunity to observe the witnesses being taken through their paces on the full gamut of their evidence has been truncated. On the other hand, the tribunal is not sitting wholly divorced from the immediacy of that evidence. It is being asked to place central reliance upon the oral phase of the hearing. Let me conclude with the closing submissions in the modern arbitration. Sometimes there are no closing oral submissions. Sometimes there are limited submissions orally and then post-hearing briefs, which often follow. Often one does not see the degree of Socratic dialogue as per a common law hearing, and often indeed one sees counsel who would prefer to deliver a carefully prepared closing speech, civilian-like, rather than brook annoying questions coming from a tribunal. The post-hearing briefs have a civilian flavour to them. They are yet another chance to present your case in a carefully composed documentary form, one step removed from the immediacy of the witnesses that have given their evidence. And that brings me really to the fourth section of my paper, which is to offer, perhaps humbly, 4 suggestions for modern international arbitration to make sure it is not simply an ugly duckling. It is not simply a lowest common denominator between these systems, but it is drawing on the best of both. My 4 suggestions are these. Firstly, as many of you will know, Neil Kaplan here tonight was an author, or perhaps the author, of the idea that prior to the first procedural hearing, leaving aside whatever documents the parties had already filed, there ought to be a very short submission on each side where each party looked forward and said, this is what we see as the real issues in the case, and perhaps more importantly, this is how we see this case being managed between now and the hearing, and what shape we think the hearing might possibly take. I would thoroughly support that proposal, because what that leads to is a first procedural order which is attuned as far as possible to the way in which, in this particular dispute, the various common law, civil law challenges I've mentioned are going to be grappled. My second suggestion is that assuming the civilian memorial method is adopted, and I say this without criticism of any arbitral tribunals, of course, I would urge tribunals to make more use of the memorials than sometimes is the case. And what I mean by that is I'm against the hands-off approach where the memorials are filed and then there's a long period and then there's a hearing, and then the arbitrators are then fully engaged with those memorials, if that's what's happening. What I am urging, and this requires the parties either to have agreed or for the tribunal to have made its intentions transparent, and it assumes that the size of the matter justifies the cost. I'd like to see tribunals encouraged to devote several days early on to a careful study of the memorials, indeed to a private conferral on them, leading to an extended second procedural hearing at which the parties in the tribunal can grapple with how the civilian common law challenges are going to be dealt with moving forward to the oral hearing. What I would like to see happen at this second procedural hearing is that the parties and the tribunal, first of all, clear away issues that are on the periphery. That witnesses whose evidence is there but are collateral to the main game can be eliminated from the oral hearing at this early stage. Conversely, where the credit or demeanour of certain witnesses is critical, it may be that there be an agreement that they give their oral evidence in chief so that they can be assessed in person in a common law sense, rather than merely having it read through a document. Brown and Dunn will be addressed at this stage. And also at this stage, the expert's evidence may enable a decision to be taken that they will not be required at the oral hearing because their written material is sufficient. I'd also see at this second hearing that the allocation of time at the final hearing will be addressed. It's relatively straightforward to say each party should have approximately the same period of time, but there are a myriad of ways in which that principle of fairness can be implemented. Some civilian arbitrators I've seen take that principle to this extent that each party can allocate any part of their time to any part of the process they wish, whether it be submissions, cross-examination, witness evidence, or so on. In other cases, what I've seen is the tribunal laying down the broad parameters, so-and-so time for oral openings, so-and-so time for oral closings, the balance for evidence as each party wishes. In yet other cases, I've seen tribunals attempt to grapple themselves with which witnesses are important and direct the parties as to how time is to be allocated across particular witnesses. My third suggestion concerns the early opening, which Neil has also pioneered. I think if at this stage of the matter, the degree of attention that I've suggested has been given to it, early opening can then be squarely focused on presentation of the legal argument because the procedural matters have already been largely cleared away. And what I would like to suggest for the early opening is that it should take more of a common law flavour in the sense that counsel should expect that the well-prepared tribunal has questions they want to raise already. It's not an occasion simply for a prepared speech. And counsel should expect that receiving those questions, they will either be able to answer them on the spot, that's the ideal, or second best, they will then have the answers for those questions at the oral hearing themselves. So where does that leave us for the final aspect, which is the oral hearing itself? What I'm urging, which I hope is not a counsel of perfection, is that the tribunal members should come to the hearing and be seen to come to the hearing with the full preparation of a civil law judge. Each member of the tribunal should have almost as good an understanding of the entire body of evidence and legal argument as do the counsel themselves. The oral openings at the final hearing should allow counsel to emphasise their key points and what they seek to establish from the evidence that follows, but counsel should already expect questions from the tribunal. In the common law style, I would expect the parties to lead their witnesses in chief and take the primary role in cross-examination of opposing witnesses, allowing some time for the tribunal to ask questions. I'm not urging in general that the tribunal would take over the primary role of questioning the witnesses as per a civilian model. There need to be clear ground rules already laid down as to how far Brown and Dunn governs the questioning. But even if it does not strictly apply, I would suggest that as per a common law model, counsel should ensure, at least for good advocacy purposes, that the substance of their ultimate case on the core issues has been squarely advanced through the cross-examination. As to oral closings, I would prefer and urge more of a common law approach where counsel should be prepared to go into oral closings either immediately or with only the shortest of breaks, and should be prepared to submit to considerable Socratic dialogue in that process, rather than, as I've said, the reading of prepared speeches. If these steps are taken, the preparation of the award can be substantially advanced in the period leading up to the hearing. It can be completed relatively shortly after the hearing. And in addition to the other mandates of an award, what I'm urging is that it should be transparent as to the methodological choices and techniques which the tribunal has adopted to meet the common law, civil law challenges that I've identified in this paper. Can I just conclude by saying that as one with some experience both as an arbitration practitioner and in domestic courts, I can attest that when international arbitration meets these challenges at its best, it not only is delivering a better service to the individual parties, but it is also improving the practice occurring in our various domestic courts. I thank you for your attendance tonight.
Thank you very much, Mr. Justin Gleeson, SC. And now I'll hand it over to Neil Kaplan. Neil Kaplan, you're going to do a discussion with Justin.
Right. Well, thank you very much, Justin, for that very interesting speech. Some interesting ideas. Let me take you back to a foundational issue. As you know, Toby Landau, when he gave a lecture here a few years ago, said that there was really no point in having witnesses at all, that their recollection is useless, and you're much better off to rely upon the documents that are contemporaneous. That theme was followed up by Lord Leggett, not only in a decision he gave in the High Court, but also in a keynote address he gave to the Supreme Court, I think, in October 2022, where he really questioned how useful witnesses were. What do you think about that? Do you think witnesses really help at all? Don't you find that most often they're trying to put a gloss on documents that are before you, or to argue a case which their advocates should be doing?
Well, thank you, Neil. So what Neil has demonstrated then is the skills of a fine common law cross-examiner, because he's put to me a question, it's a leading question, he's put the ultimate proposition, don't I agree with X? And in that question, he has led up with his various premises. My answer to the question is, I disagree with the Toby Landau and the Justice Leggett view. I still think the witness evidence, properly controlled, is often central to the proper resolution of the case. And I think that the role of the tribunal, like a common law judge or jury, does include an assessment of the demeanour of the witness as well as the content of the evidence. Undoubtedly, the documents are important, and they're now more important than they ever were in the past. Usually, there are now too many documents, as we all know. And a huge part of the forensic skill of counsel is to assemble those documents in a way where, when one is then listening to the witnesses, the tribunal can form reliable views as to what to accept and what to reject. But to the extent Toby presented the psychological argument that common law judges think they're better at discerning the truth teller from the liar than they really are, I would respectfully disagree.
Well, of course, since Toby did his lecture, there have been some sociological studies into this. We now have some evidence. The evidence seems to suggest that there's about a 50-50 chance the judge is going to get it wrong. I mean, do you really think you can look at someone and tell whether they're telling the truth? And if that's right, how do so many fraudsters get away with it?
Well, as I was suggesting, because we do have the documents, and if the documents have been properly assembled and the chronology is good and is strong, one can, through, I think, a rigorous process, make considerable headway towards finding at least the relative truth I've described. Can I give one example from the Australian context? Some of you might have heard of a very large defamation case we had, which was Ben Roberts-Smith against Channel 7. Ben Roberts-Smith was our most distinguished Special Services soldier with a Victoria Cross for great bravery. Channel 7, or Channel 9, whichever one, perhaps Channel 9, published a carefully prepared piece accusing him of having orchestrated 5 war crimes in Afghanistan, either directly or through ordering his subordinates. He sued for defamation. They pleaded truth. The case went for months and months and months. There was a vast amount of oral evidence, including some of the Afghan locals gave evidence either by video or in Australia, deposing to what they saw. There was the most rigorous cross-examination. There were also a lot of documents. There were also pieces of real evidence. For example, Robert Smith was proven to have hidden a series of computer hard drives in his children's lunchboxes in his backyard. The judge provided a reasoned judgment, which I think went for about 2,500 paragraphs. In that, the judge found he disbelieved Ben Robert Smith on issues A, B, C, D, E, and F. He gave the most detailed of reasons. He referenced it to the documents where possible, but it was a part of his reasoning that he looked at the man in the witness box, he looked at his demeanour, he considered it in the light of everything else that was before him, and for reasons A, B, and C, which took all these pages, it was his view ultimately that Ben Robert Smith was a liar. Now, that case could not have been decided one way or the other without a judge forming a view in the end whether the witness was a liar. In Robert Smith's favour, I should say, the appeal went for 10 days in Australia 2 weeks ago. That's a long appeal, but that's the common law system. The appeal is reserved. There were a series of challenges raised in the appeal, but to me at least, although that's an unusual case at the longer end of the spectrum, that is the common law system still working in a valuable way.
But on the other hand, it is a libel case or defamation case. And the context of my question was really in the context of commercial cases. But do you really think it helps to have a managing director of a company give evidence about an agreement he entered into 10 years before, when it's all documented in emails or telexes or statements? I mean, what's the point?
Well, part of my emphasis on the benefits of a common law pleading in terms of isolating true factual disputes is, I would agree, for many issues, that evidence is not of much use one way or the other. And often, if the witness statements are going into issues of state of mind without careful attention to whether state of mind is even relevant, then the entire process is a distraction. I agree with that. But in a case where the managing director says, I was induced to enter this agreement by a negligent misrepresentation, the state of mind of the managing director, yes, 10 years ago, is the critical fact which the judge or the arbitrator has to decide. Now, with all of the frailties of recollection, all of the problems of the evidence might have been influenced by the fact there is now the dispute, that is still the ultimate question the judge has to decide. And at least for me, there is still benefit in saying that witness gets the chance to present their evidence, to say what is their best recollection of their state of mind 10 years ago, and the tribunal gets to rule on it.
Okay, let's move on to pleadings and memorials. My experience in international arbitration is that everybody uses memorials, whether they're common law or civil law. I know Australians love their pleadings. I can't stand pleadings. I spent all my life at the bar in England doing pleadings. I never want to see another one. I can't stand reading that the 13th sentence in paragraph 43 is denied up to the first colon, thereafter no admissions are made. Do you really want to go ahead with using pleadings, or do you think that we're in the right area now using memorials which have the witness statements, the experts' reports, and the documents attached to them?
I think that one, the short answer is yes. We are now broadly in the right area, although I have to say I have seen some arbitrations where the practitioners were not Australian, in fact, they're English, where the parties agreed upon old-fashioned pleadings, but the issues were very neatly confined by those pleadings. I'm not at all encouraging, I agree with the first 4 words of paragraph 95B, and I disagree with the rest of them. That is worthless, I agree. There are some cases where party autonomy, good counsel, the pleadings can have a role to play. But if we accept that in general, it's going to be the memorials. Then the point I was trying to at least raise for consideration tonight is, are we making enough active use of the memorials? Having put the parties to that expense, and they are expensive, having taken, say, a year to get those memorials done, to get, say, 2 rounds done, what are we doing next in the process?
Let's just talk about disclosure and the common law, civil law, because what I found is that the civil lawyers, when they're involved in an international arbitration, love to embrace all the worst aspects of the common law system. And they love the idea of asking the other side to produce all their documents because they can't do it in their own jurisdiction quite so easily. And they love cross-examination because they don't get much of that. So in international arbitration, we do see a blend of the two systems, which is almost seamless today. That's rather a comment. I was going to ask you about disclosure. In a common law system, we have this horrible disclosure system. Let me ask you this first of all. Have you ever come across a smoking gun that justifies the millions of dollars?
I have actually.
How many?
Quite a few.
Well, you're a very good cross-examiner.
Or I'm very lucky. Maybe I know where the smoke comes, but can I give one example which is on the public record, where disclosure was valuable? If you take the jurisdictional dispute between Australia and Philip Morris, Australia sought disclosure of documents which might bear upon Philip Morris's intentions when they restructured their companies in order to get a company in Hong Kong, which could then take advantage of the Hong Kong Australia BIT. That was vigorously resisted by Philip Morris on the sort of grounds Neil has just mentioned. Disclosure never produces anything. The panel had 2 civilian lawyers on it and 1 common lawyer. With some difficulty, we got a very tightly confined order for disclosure of documents. The documents were produced. Only 4 documents were produced. Every other document privilege was claimed over for the reason that, and I didn't know this at the time, but with certain companies, you constitute every person in the company an assistant legal officer charged with selling product, etc. And so you can claim privilege over the works of everyone in the company. So the result was that in this case, Philip Morris had 78 lawyers. And so every email that we wanted, which might have actually shown us what was in their mind, was subject to the claim of privilege. However, we then organised all of those documents in chronological order. And I think this is interesting, Neil, the tribunal, and this is perhaps controversial, although privilege was claimed, the tribunal ordered that the documents still be listed by reference to sender, recipient, date, and something like the subject line of the email or the header of the email. So once we reorganised all those chronologically and we had all the email headers, even though we didn't have the internal communications, you could actually tell by way of inference what had gone on. So that was an example where limited disclosure plus some creative work with that disclosure, in fact, gave us evidence that we otherwise only had an inferential case. So again, maybe I'm betraying a common law flavour here, which I'm trying not to do. I've also seen a lot of wasteful discovery. I've seen a lot of expensive discovery, and I've seen a lot of difficult discovery or disclosure disputes where the tribunal gives reasons which don't really tell the parties terribly much about why something was given and something else was not given. So it is a problem still.
Well, defending the tribunal, I mean, that's an enormous task at an early stage of the proceedings when the tribunal's not really as au fait with the issues of materiality and relevance they're going to be after the hearing. I don't know, you are an arbitrator, so you know, but it's a very difficult task to deal with some of these complex requests for documents when you're not on top of the case.
Well, I think that's, I agree with that. That's difficult. And another difficulty is I've seen two views expressed as to whether, when the parties frame the requests, it's not the job of the tribunal to try and rewrite a request down to a more reasonable request. One view is no, you look at that request. If it's not shown to be material, if it looks oppressive, you say no, and then if they wish to bring another request, they do. I've seen another approach where the tribunal tries to find the reasonable kernel within a larger request. So I'm not sure.
One of my colleagues was reading a 300-page request for documents written by someone else. He was the arbitrator. And when he got to page 201, counsel for one side had written, "Lost the will to live." So I think describes what the problem. Now, are there any questions from members of the audience? Yes, sir.
Do you think that it is important for an institution to set out right in the beginning whether it will follow the common law system or the civil law system in its procedures? Because it can, in some cases, amount to denial of justice if you follow one system against the other.
I think what I'm urging is that it not be as simple as we will follow one or the other, but that the questions inherent in that be exposed at that earlier stage. And if the parties can agree on how the particular issues are going to be resolved, that will be built into the first or the second procedural order. If the parties cannot agree, I am suggesting that the tribunal should, as far as possible, be transparent as to how it proposes to deal with those issues. So I've seen a number of matters where tribunals, either of their own will or on request of a party, have had to grapple with Brown and Dunn. I don't want to sound obsessed by Brown and Dunn, but I'm obsessed by Brown and Dunn because I come from New South Wales. Everyone in New South Wales is obsessed with Brown and Dunn. But I've seen that as an issue, which is a subset of the common law, civil law divide, being actively exposed. And some tribunals have said, yes, we do expect it to be complied with, or we don't expect it to be complied with. So I am urging those issues be brought out into the open as soon as possible.
Yes. All right.
Mr. Gleeson, thank you for your speech. I have a question about witness statements and actual examination in chief. In my practice, I saw quite a number of procedural orders that either limit examination in chief or exclude it altogether. In which scenarios you think it's permissible or desirable to have actual examination in chief?
Thank you. I'm not a fan of saying it always has to be reduced to the written statement, because what has actually happened in Australia in the domestic courts is we've had a transition from originally basically all oral evidence, then to basically all witness statements. And then judges have said, when I'm actually dealing with issues where the conflict between two witnesses is at the heart of the entire case and demeanour and credit are central, I will require the witness to give the evidence in chief, at least on the core component. And I have seen cases where that has produced a far fairer result, because instead of the witness just tendering the statement and then being thrown straight to the wolves, it might take half an hour, but the witness is asked what happened in the conversation on the 12th of January 1991 according to you, and the witness leads that evidence in chief. Now, it's time consuming, and so it only should be reserved for the appropriate cases where it really matters. But all I'm saying is I have seen in common law courts limited oral evidence in chief, in fact, producing a fairer result.
It's a cricketing analogy, isn't it? Getting their eye in, getting comfortable for a few minutes.
Well, that's it's at least that, but I have actually seen. But if it's a dispute over a conversation, there is some benefit in the tribunal simply hearing the witness's version orally. There might have been a witness statement prepared in advance to indicate the type of evidence, but this is what I say happened on those days.
Justin, just back on the rule of Brown and Dunn, in my experience in arbitration, that's rarely raised as an issue, or at least not discussed as a ground rule prior to a hearing. And I wondered, just in your experience, if you were sitting as arbitrator, and this is for Neil as well, would you hold it against counsel for not putting forward contradictory evidence to a witness during a hearing?
I think sometimes we actually say in the procedural order, it's not necessary to put everything. It depends what it is. I mean, if it's a serious allegation, if it's a fraudulent, if you're saying that a witness is acting dishonestly or fraudulently, it will be extraordinary not to give him an opportunity or her of dealing with it. And if you don't put it, it's not worth much of an argument at the end of the day. So it depends on the nature of the point. But I don't think you have to put to a witness in arbitration in a commercial case. In a commercial case, every point of difference between you. It's apparent on the pleadings, it's apparent on the witness statements, it's apparent in the documents at the time. Yeah. The question is.
Hello, question for both of you or either of you. Yeah, my practice is half litigation, half arbitration, so I'm used to the common law traditional approach. And Neil's certainly right to say that in arbitration, claim submissions are now invariably more of what you call in your notes civil, where you propositions of law and annexing important documents. But it's now going further, and it's now common for witness statements, experts reports, everything to be served at once with the detailed memorial style claim submissions. Now, to me, firstly, it's very expensive, and it does lose some of the benefits of the litigation system. So, I mean, if you've got sensible counsel on both sides, a well-drafted defense can admit quite a lot of the claim. So you can deal with the points that are not going to be in dispute later. And if you leave the experts reports to later, you can define the issue. So either the parties agree the issues. If you can't reach agreement, the tribunal can rule and define the issues. I mean, those are just two benefits to me that I can identify that are lost in this modern approach of serving absolutely everything all at once. So I know it's going that way. I don't know if it's, I mean, in your note, you call it civil. I think it's perhaps an American thing that's spread around the world. But I mean, I'm getting used to that in my old age. But I do think some of the benefits of the litigation system are lost with that new trend. What do you say to that, Neil?
Well, I would say that it is possible and often done today where you have a memorial that doesn't contain the expert witnesses. I think it's dangerous to have the expert witnesses' statements served with a memorial because it then takes away the opportunity of the tribunal to fashion a proper protocol for the experts, which will save time and be more helpful to the tribunal. So I don't think you have to have the full Monty, as it were, the full memorial with everything. You can say we will have a memorial, in other words, like a more story of what the case was about, rather than a pleading, and leave some of the other things to later. I think that's possible. I've seen that. I see a hand at the back. Thank you.
Yes, hi.
Sorry, I didn't see you there, Donna.
Hi, Neil. Justin, yes. Just coming back to disclosure, because in looking at the title here, I think we all want arbitration to survive and prosper, and I think that discovery or disclosure is really one of the key things that bogs it down in time and cost, and that's really the buzzword for now 30 years. So I think that just when you're referring to Australian Philip Morris, but that was really based on, I think, the fact that there was really a suspicion that there was forum shopping. So it was trying to prove something, asking for that disclosure that you already knew about. So I think that's a little bit different from the smoking gun American style, where you're going to ask for everything just in case you find something in it. So isn't that more reasonable if you think that there's something that needs to be proven? And it's a little bit similar in the civil law system. You put in what you have each side, and then you can ask for different, types of documents when you need them. So I think it's a little bit different from a smoking gun, because I wouldn't want to encourage anyone to do that American style.
I think I agree with that. I think my example was, it wasn't the pure smoking gun, and I'm not encouraging the old-fashioned general discovery in the hope that we will find something in it that we've never heard of. But I adhere to my point. I have seen cases where people were not abusing discovery. They were asking for broad categories of documents, and they found things in them they could never have otherwise had. So that's just my perspective on it.
I think you have to do a cost-benefit analysis. How many billions of dollars have been spent on disclosure over the last few years, and whether the few documents that are really important justify the expense. Nothing's perfect, and you ought to make a value judgment. Any other questions before we ask Anthony to? Yes. Yes.
Charlie Chen from Harcourt Chambers. First of all, thank you, Justin, for your concise but informative talk. I've got a question for you. In your experiences, you have come across a huge number of arbitrations. Can you share with us, in terms of conduct of arbitration, what's the best arbitration you've ever seen? And 3 features for it. And by the same token, what is the worst arbitration and 3 features of it? Thank you.
I think I'm going to claim legal professional privilege.
Any more questions? Last one. Anyone? If not, can we ask, for example, Anthony Corkett from Herbert Smith Freehills to come up and say a few words? Anthony and the firm have been supporting this event, and we thank them very much, as well as the Hong Kong International Arbitration Center. Anthony.
Thanks, Professor To. I'll stay seated because I shan't say too much and keep you from the book launch or keep you from the refreshments. Herbert Smith Freehills is delighted to sponsor the series. I'd like to thank Justin for an excellent lecture. I think it's truly a thoughtful and thought-provoking contribution to this series of lectures. I liked the turn of phrase in the opening part of your lecture, Justin, describing arbitration as a rich and diverse laboratory, and we see the mixing of the best of both systems, the common law system and the civil law system. But I think that's also a reminder that if we're in a laboratory, we can innovate, we can try things that are different. We're not in a kitchen where we're putting in 2 cups of memorials, 16 cups of document production and baking in the oven for 3 days at the hearing. We can do things differently to try and make the system better for everyone. So thanks again to Justin. Thank you to Professor To and Professor Croft, and to Neil for your contribution to this evening in particular. Thank you to the audience for attending. I hope you will all stay and continue the discussion over drinks afterwards. Thank you.
Thank you very much, Anthony, and also Herbert Smith Freehills. Could I ask Thomas to come up and maybe to present a souvenir to Justin for his sort of his assistance with this lecture series? Yeah, you want to say a few words as well? Okay. Justin, can you come up? Yes. Okay. Now, on behalf of the university and also, for example, Neil Kaplan, Herbert Smith, and the Hong Kong International Arbitration Center, we would like to thank you for spending the time with us to give us your insights into international arbitration and your experience. Thank you very much. Thank you very much, gentlemen, Thomas and Justin. Neil Kaplan, are you going to kick off this book series and mention something about it? It took us some time to do this book, by the way. It wasn't an easy task, wasn't it?
I won't keep you long from your drinks. 34 years ago, I sat in this room and heard Lord Goff deliver the first lecture in this series. Now, that's what I remember. It may have been in another room. My recollections let me down. So I just want to make the point that memory can play tricks with you. But as I set out in the preface to the book, which we're about to launch today, I was at that time chair of the Hong Kong branch of the Chartered Institute, and Lord Goff was at that time the honorary president. And as Hong Kong was then, and it still is, a very large branch indeed, he was invited to visit and gladly accepted the invitation. And when my good friend, the late Derek Roebuck, who was then dean of the faculty of City U Law School, heard of Lord Goff's impending visit, he said, why don't we ask him to give a lecture? So we did. And there followed 27 more, and you were privileged to hear the 28th this evening. Sadly, we've lost some of our lecturers, Lord Goff, Lord Bingham, Lord Mustill, Arthur Marriott, and in the last few weeks, we've lost Andrew Rogers, who revolutionized the way litigation was conducted in New South Wales. We've also lost far too soon Professor David Caron and Johnny Vida, and also Pierre Lalive. And just a few weeks ago, Fali Nariman passed away, and he was at one stage a president of ICA and a leading Indian arbitrator, as many of you will know. But the rest of us are still soldiering on. It occurred to me and others that it would be a very great shame to lose the collected wisdom of the lecturers. It's interesting to see what they said then and how things have developed thereafter. Thankfully, none of the lecturers who are still with us said that that's what they thought then, and they didn't agree with what they wrote at the time. But some of them did add a little addendum to what they said. We had some difficulty tracking them all down, but most of them were found and have helped. I was very pleased to have Robert Morgan as my co-editor, as he edited all the lectures and corrected some original mistakes too. I'm grateful to him for his painstaking work. May have taken a while coming, but here it is, off the press today, first time I've seen it, and available for purchase tonight by credit card or cash. So please go and buy one. I'd like to thank our sponsors, Herbert Smith Freehills, for their generous support for the Goff Lecture series and their hospitality tonight. I'd like to thank Judy and her team at City University of Hong Kong for all their help in putting this book together. And Christopher Toe, of course, has always been extremely helpful all the way through. Thanks due to Marnie Shaw and her BD team at HKIAC for putting this all together, even though they are, at the moment, fully immersed in preparing for ICA Hong Kong 2024, to which I hope you're all coming. If not, please see me after the speeches. So thank you very much indeed for coming, and I hope you get a chance to look at the book and enjoy the lectures. Thank you.
Thank you very much, Mr. Kaplan. Just to say a few words, on behalf of the Dean of the Law School of City University, unfortunately, he cannot be here because he's in South Africa signing some cooperation agreements with various universities around the world. But he would like to say a few things to say that he would like to thank everyone here, Neil Kaplan for supporting this series for how many years now? 28 years, all the way through, okay? And also our speaker today, Justin, Herbert Smith Freehills, and also, for example, Thomas, who came from the university to support, even though he's not this is not his field, but he's willing to support it. And also, I'd like to thank some of the students here who are doing the Masters in Arbitration courses, some of the past students and the current students. Thank you for coming. And also for you, ladies and gentlemen, to give us your time to understand, for example, what Justin has to say about international arbitration. On this note, please do support us in the years to come. Thank you very much.